Welcome and thank you for joining me for Tax Break. This is a podcast about South African tax for South African tax professionals and practitioners. My name is Pieter van der Swan, and in each episode I share my thoughts with you on a topic or a recent development in the field of South African tax. And I do my best to do it in the time that you need to make yourself a nice cup of coffee while you need a bit of a break from work. Our topic for today is a case that made the news headlines, the case of SARS versus Coronation. And it's a case that went all the way up to the Constitutional Court. It dealt with the Controlled Foreign Company Rules, or the CFC rules as we normally refer to them in the shorter form. And I think for these rules, it's interesting to see that not long ago there were no real cases or case law dealing with it. And now there's actually quite a few cases. A few years ago there was the Sassel case that dealt with these rules or the dispute involving them. And now there's been this dispute between SARS and Coronation. So the body of case law is definitely building. Before we go to the detail of what the dispute between SARS and Coronation was, let's perhaps take a step back and just ask ourselves the question again, what exactly is a CFC? And I think the right point to start that discussion is to go all the way back to when we transitioned as South Africa to a residence-based tax system. So what that means is residents are taxed on their worldwide income or on a worldwide basis, of course with a rebate for certain foreign taxes or acknowledgement for certain foreign taxes that you may suffer. And non-residents are taxed on their South African sourced income only. So when South Africa transitioned to this system in the early 2000s, this system created an opportunity, if it wasn't for the CFC rules, to set up a non-resident structure that was still controlled by South African residents. Once you were able to set up such a structure, some of your income that would have otherwise been taxable in South Africa could have accrued to that structure and then escaped the South African tax net. You could probably also take it a step further to say that you could have even diverted some of your income from South Africa into this structure. For example, by paying a fee from the South African entity to the offshore structure that would be deductible on this side in South Africa, but escapes the South African tax net in the offshore structure. So the CFC rules are really a set of anti-avoidance rules that target these kind of structures. And what they essentially do, they require the shareholders of the offshore company, the foreign company, to impute a portion of its profits back into the taxable income of the shareholder. And what that does is it restores the tax base, so in other words, the shareholder's position, the South African resident, to reflect the income or the profits that it would have reflected at the profits that accrued in the foreign structure, accrued directly to the shareholder. But as with all these rules, there must be a balance between countering avoidance and not being an obstruction for legitimate business by, for example, causing these entities to be uncompetitive in the environments where they operate because of the level of South African tax that's imposed. Now, the way that the rules achieve this balance or try to achieve the balance is through the FBE exemption, so the Foreign Business Establishment exemption. What this exemption says is that if your income or the income attributable to a foreign business establishment, you don't have to impute that income back into your taxable income, subject to certain further rules. And if we look at the term FBE, Foreign Business Establishment, it's a defined term and it depends on various, there's various requirements relating to the duration of how long the business must exist, that it must be carried on through a fixed place. It considers the structures, the staff, the facility that the business uses. And it's all these things point towards there being enough substance to justify exclusion from the anti-avoidance rules of the CFC provisions. So in other words, to say, but you've got a real business on that side, it's not just the risk to the fiscus that you are just trying to obtain some sort of a tax advantage is low enough, and therefore you don't have to impute. Right. So back to the dispute between SARS and Coronation. It was all about the FBE exemption. So in short, the facts that were of that case, the South African parent had an Irish subsidiary, and the Irish subsidiary was a collective investment scheme fund manager. Interesting or necessary to perhaps understand is that this entity was required by the group to offer customers the opportunity to invest in Irish collective investment scheme opportunities, because South African entities, in terms of the Irish law, couldn't fulfill this function of being collective investment scheme fund managers in Ireland. So what the Irish company then did, the fund manager, it appointed an investment manager or investment managers where they were based in the UK and in South Africa to do the investment trading activities. So that's then really the investment buying and selling activities. And SARS's view was that because this function of investment management was outsourced, that caused the Irish subsidiary not to have sufficient substance, so not to be suitably staffed to satisfy the requirements of the FBE definition. The taxpayer, however, argued that what SARS was looking at and describing was not its business model. Its business model involved having oversight over the trading, but not necessarily doing the trading itself. So it was what the taxpayer described as a delegated fund model. Right, and this dispute, as I've already mentioned, went all the way from the tax court through the appeal court to the constitutional court. Initially in the tax court ruled in favor of the taxpayer. SARS then appealed, and the appeal court, the Supreme Court of Appeal, ruled in favor of SARS. And in the constitutional court, the court ruled in favor of the taxpayer. The court considered, in getting to this conclusion, it considered the license that the taxpayer held in Ireland. It looked at the business model, it looked at industry practice, and it concluded that the Supreme Court of Appeal erred by not distinguishing between an investment manager and investment trading activities, or a fund manager in the broader sense, which was what the Irish company was doing, and trading activities, the actual activity of conducting the trading itself. And on that basis, the Constitutional Court concluded that the Irish company had enough staff and enough substance to the business to conduct its own primary operations. I think there's a few important points if you look at the Constitutional Court's judgment, and just a few that I would like to highlight. The first one is that the Constitutional Court ruled that when you apply the FBE exemption, you need to look at the actual business of a taxpayer and ask yourself the question then, but is this business appropriately staffed for the actual business? Or does it have appropriate or suitable facilities for the actual business? Rather than looking at notionally or theoretically what the business could have been and whether it would be suitably staffed for what it could have possibly been. What the court then, however, warned against was that there are some types of business models or businesses that you can describe that would be so narrow that they should not meet the substance threshold. And when you look at those kind of businesses, these concerns around whether they are suitably staffed, whether they've got suitable facilities, whether they've got suitable structures, that's in those cases, these types of businesses wouldn't necessarily meet the substance threshold that's set by the FBE definition. And lastly, the court also said that the FBE rules, they don't counter outsourced business models. If they were to counter these types of business models that are common business practice, that would impede the competitiveness of South African controlled foreign businesses. So in closing, I think it would be interesting to see the topic of what the effect of outsourced business models should be on the FBE definition is definitely something that is on the National Treasury's radar. And there was a proposed change to the legislation a year or so ago, but that was held back pending the outcome of the Coronation case in the Constitutional Court. So I think it would be interesting for me to see what the National Treasury does going forward, if they do anything, especially in light of what the Constitutional Court said about the FBE rules that shouldn't impede on the ability of South African businesses to follow an outsourced business model, which if the FBE rules do not allow for that, would affect the competitiveness of these businesses. That's about all for this episode. Thank you for listening. And if you enjoyed this podcast, please subscribe on your podcast platform and tell your colleagues and friends about it. If you have any questions that you would like me to discuss in a future episode, you are more than welcome to email it to me. My email address is in the show notes below the episode. And as always, nothing in this podcast should be construed as tax advice or even a substitute for fact-specific tax advice. Until next time, goodbye.